Oh, now it's live.
All right. Hi. Welcome
Hello.
to Coffee Chat. It is a MCPS no school day, so we are live from home.
Yes.
Since, as many of you know, our office is closed for MCPS holidays, days at schools, closed, snow day, rain day, wind day, whatever MCPS decides to close.
Yes.
So, but it's been a few weeks and we didn't want to miss another coffee chat.
Yes.
So what are we chatting about today, Lindsay?
So we're going to start a little series of 10 estate planning mistakes to avoid. So things not to do when you're thinking about an estate plan. So we'll cover the first 3 today, and then we'll do the rest over the next couple of weeks.
Sounds good. So
number one,
not having a plan.
Yes. Why is that bad, Megan?
Well, if you don't have a plan, there is a plan, but it's the state of Maryland's plan for you. And oftentimes that doesn't match what most people want. So I was thinking about this the other night, and who does the state plan work for? I think the only category people I can think of are maybe married couples with adult children, single family, single marriage, adult kids, they're older, and you don't care if they receive their inheritance outright.
Right.
It's probably the only.
Yeah, and if you don't own a business as well.
Yes, and you don't care about probate.
Right.
Or having control over anything. Maybe it's only adult children with only child families. I don't know. It was hard to think of where it would be good, right? So
yeah, because I think with the probates that we've seen for people who don't have a will, or even people that might have an out of date will, there's generally some part of that plan that the family is like, oh, this is not what they would have wanted. And it might be something minor, might be something major, something as simple as, I have teenagers, but I wouldn't want them to inherit right now. I would want it to be put in a trust, which it is, but it's only until they're 21. And maybe you would have chosen for it to be longer. So it could be something small like that, but it's generally not, oh, well, that's cool. That's totally what the person would have wanted. Right. So yeah, that's a really good question of who does it actually work for. And I'm sure when the legislature was putting this into effect, they had this vision of a perfect family with no complications, and that's who they were.
Well, we're trying to figure out what can we put in place that would probably work and be the most fair for everybody involved.
Right.
And I think it leads us into our second not to do, right, is planning for incapacity, right? Make sure or don't, that's a double negative. I was going to say don't not plan, but that's make sure you have an incapacity plan, right? Don't forget incapacity planning. And there is no default for incapacity planning. Well, there is.
Yeah.
But it's not pretty, right? It's guardianship, and it's expensive and long, and your family's already stressed out. So you don't have a plan. There's no default incapacity plan.
Right. And then you run the risk with guardianship of having somebody named that is a close relative, but maybe has totally different views on everything than you do. And that's not who you would have chosen to be the person in charge of your healthcare decisions or your finances and other affairs. So again,
or a complete stranger.
Well, yeah, it could even be that. So yeah, have a plan for incapacity. And this could be, when we say incapacity, we're talking about temporary or permanent disability. So it could just be that maybe you're in a serious accident and you're laid up in a coma for a month, or you have something more, more permanent like Alzheimer's or dementia, where you're not really coming back from it. So it could be either temporary, or permanent. But you want to have a plan. And then the other part of that we talk to clients about is if you have minor kids, what happens to them? You become unable to care for them temporarily or permanently due to injury or illness. So you want to have that plan, because CPS could be the default for that. And that's not what any parent I've ever spoken to would want.
Right. So
speaking of minor,
and what's number 3?
Naming the right beneficiaries. So when you have accounts, retirement accounts, life insurance, you can do it on bank accounts, anything where you can name a beneficiary. Make sure those beneficiaries are what we call good beneficiaries. That is somebody who is over the age of 18, who you actually want to inherit the money, and who is not an ex-spouse. Because if you name somebody as a beneficiary and then you divorce them, well, your will might not name them anymore. If you don't update that, they're still getting that inheritance, because the will doesn't control those beneficiary designations. So yeah, make sure those are up to date, and make sure you have a contingent beneficiary. That way, if your primary beneficiary passes away and you don't get around to updating, it doesn't go to someone you wouldn't want or go to your estate.
Yeah. And you don't have to name one person, right, on those beneficiary designations. So you can identify how you want accounts split up. But similarly, right, make sure that there is contingency plans in place, right? If you give 50% to a sibling who then predeceases you, where's that 50% go?
Right.
To go to the other.
Yeah.
Yeah.
And, or, what if that sibling or your beneficiary becomes disabled and they shouldn't receive inheritance because they're getting medical, government benefits? You would want to update that to accommodate for that. But the other thing, why do we recommend not naming minors as a beneficiary, which is very, very common?
Yeah. It is. I think everyone we see, right, names a spouse and then their kids as contingent. Yeah. And when you name a minor child as a beneficiary, with the purpose or thought that it's going to skip probate and they will just get it directly outright, it actually does the opposite, and it pulls them right back into probate. So if your goal is to avoid probate, and you're using beneficiary designations to do that, if you name a minor child, you're not avoiding probate, you're pulling it right back into probate. If your will doesn't provide for testamentary trust or whatever, then it's the same situation as he was speaking about earlier, that the money will be put into a trust, but it's a court control trust in which the beneficiary gets the money outright at 21. So,
and if you don't have a will, you don't
that have said, "Oh yeah, at 21."
Yeah. And if you don't have a will, you don't get to choose who becomes the trustee of that trust. The court does. And a lot of times it's not who you would have chosen. So again, it's all about choice and control and making sure things happen the way you want them to happen. And the best way to do that is with a plan. So speaking of which, our event this week or this month, we're doing an in-person event at Two Chimneys Cider Works over near Damascus. It's on 108, and it's called Pints and Planning. So it's April 25th from 6 to 8. It's a Thursday night. Yeah. So join us. We're going to have some drinks, and we'll be talking to you about estate planning basics and all of these types of things to avoid and what to do instead. So we hope to see you there. Registration will be up soon. Yes. Registration's not up yet. It will be soon.
I'll drop the link into the comments later today. It should be up.
Perfect. All right. Awesome.
All right. Well, it's good. It's a fun chat.
Yes.
It works well from home.
I know. Hopefully it turned out okay on Facebook. So.
All right. Have a great day, everybody.